Hello friends, welcome to my channel. Today we will be dealing with the essentials of contract. All contracts are agreement, but all agreements are not contract. To constitute a contract, the following conditions are to be satisfied. First, two parties, offerer under section 2A and acceptor under section 2B. To constitute a contract, there must be an offer and acceptance. The person who makes an offer is called offerer and the party who accepts the offer is called the acceptor. Conscience ad idem, identity of mind. A contract to be valid, there must exist conscience ad idem. It means identity of mind between the two parties to the contract. For example, A has two houses, X and Y. A offers to sell X to B. B accepts the offer thinking that it is Y. Hence, there is no identity of mind, hence it is not enforceable. Capacity to contract. The parties to the contract must be competent to enter into contract. Any person is competent to contract provided that he is major, he is of sound mind, he is not disqualified by law. A contract entered into with minor is void ab initio as laid down in the case of Mohan versus Dharmadas Ghosh. Free consent. Section 14. According to Section 14, free consent means the consent that is free and which is not caused by coercion as defined under Section 15, undue influence as defined under Section 16, fraud as defined under Section 17, misrepresentation as defined under 18, mistake subject to provisions Section 20, 21 and 22. Lawful consideration. Section 2D. Consideration is one of the important essential elements for the formation of contract. It refers to both the parties. It basically means something in return. For example, A sells his house to B for 10 lakh. Hence, A's lawful consideration is 10 lakh. Similarly, B's lawful consideration is the house. In India, past, present and future considerations are not valid. Legal relationship. A contract to be enforceable, it must create a legal relationship between two parties. Mere domestic or social relationship does not give rise to legal relationship. For instance, a lawful wedded wife is entitled to enforce the claim of maintenance by filing a suit against her husband. In Balfour versus Balfour, the defendant in the instant case was a civil servant in Ceylon. When he left from England, he promised his wife to pay £30 per month, but he did not send the amount. The plaintiff filed a suit against her husband. It was held that the suit was not maintainable as it does not give rise to any legal consequences. In Badri Prasad versus State of Madhya Pradesh, the divisional officer wrote a plaintiff asking him to pay 17,000 for the contract of big trees. In reply to this, he wrote that he is ready to pay 17,000 but with certain if and buts. The Supreme Court held that by those later no contract has been made between the plaintiff and the government. The letters from the divisional officer seem to be merely an invitation to offer rather than an offer. Lawful object. Section 23. A contract is valid only when the object for which it has been entered into must be lawful. An agreement entered into with a lawful object is forbidden by law, fraudulent, causing harm to another person. Terms must be certain. The terms and conditions of the contract shall be clearly furnished in the agreement. For example, A offers B to supply 100 tons of oil. In this case, the term of the offer is not clear. In Taylor versus Pottigan, the plaintiff in this instant case promised to take defendant's land on lease for a period of 3 years, provided that it is thoroughly repaired and drawing room is decorated according to the present style. It was held that it is not enforceable since the terms are uncertain. Possibility of performance. If the possibility of performance of a contract is impossible, it is void. For example, a contract to construct a building within 2 days.